Good morning. Welcome to the October 9th, 2020 Board of Appeals meeting. We're being held virtually on the WebEx platform. I'd like to remind everybody of the protocols, what we're calling the Aloha Etiquette.
I'm sorry, Mr. Chair. I'm sorry to interrupt. I don't think we have a connection to YouTube live streaming yet.
Oh.
I'm not seeing it.
Okay.
Is it happening?
I think we do, Noriko. I think Keiko came in and said we're running.
Okay, let me double check.
I can't, excuse me, but I can't see it either. I have YouTube up on the television screen, and it's just showing all the other meetings that were performed. But I'm keep looking for a button that I got to push, but maybe not.
Yeah, I think if you reload the page, I just got it.
Okay, let me reload. Let's see, how do I do that? Okay. Well, here I'm gonna shut my mic off and give it a try. Yeah, I think
could you verify we're running?
Yep, it shows on our side that we're up and running.
Well, I see the
Bethany,
live.
thank you. It's running.
Perfect. Thank you, guys.
All right. So I was getting into our etiquette, but obviously everybody knows the rules because we had no side conversations during that pause. So that's a good rule. Please mute your device unless speaking to improve audio quality. Raise your hand and wait for recognition before speaking. Prior to speaking, please state your name, at least for the first time. Speak slowly and clearly and as close to your microphone as is comfortable. Try to limit your distractions. Send your kids to school, turn off mobile phones, anything else you might contrive to keep it quiet in the background. Give the dog a bone. We'll try to take a break each hour. Sometimes that gets a little sketchy. I'd like to begin by introducing the members of the board. Do we have, where's Stacey today? Hi, Stacey. Welcome back.
Hi, good morning.
Stacey Aguiar is with us. Steve Hirakami. Steve?
Hi, everybody.
Good to go. Heather Kimball. Hi, Heather.
Good morning, everyone.
Good morning. Justin Lee.
Good morning.
Hi, Justin. Neil Thomas.
Good morning, everybody.
Hi, Neil. With us here in the staff room is Diana Mellon Lacey, the counsel to the board.
Morning.
Also with us is Bethany Morrison, our staff member from the planning department. Rob Leisure is the staff to the board in Kona. Eric Cook may be with us. Is that the case?
No.
No? All right. Behind and supporting us is Melissa Diacan Salvador. She's the secretary to the board. And Noriko Sauer is the secretary to the board from the Kona office.
Good morning.
Good morning. So those are our board members. I'm going to announce the agenda items. Item number 4 was Ryan Maverick and Jeffrey Foster, BOA 20-000268. It was withdrawn. At this time, I'm going to take statements from the public on any items on the agenda. So if there's any members from the public here today, I'd like to receive and acknowledge your testimony. Seeing none, we will continue. I'm sorry? We have written testimony from witnesses, do we not?
Yes, but as far as just from the general public.
Bethany, did we receive any? No. Just what's in the record on appeal?
Right.
Okay.
And that was already distributed
yes.
by email.
Yes, thank you. All right, so our first agenda item, this is an appeal of the Association of Property Owners of Kona Ocean View Properties Incorporated. The BOA is 20-000270. It's an appeal of decision by the Planning Director dated March 23rd, 2020, regarding the approval of a variance application, variance 20000571. No physical address assigned. The TMK is 372604. Subdivision number was 17-0016999. Accompanying that is BOA 20000271. It's an appeal of the decision by the Planning Director dated May 23rd, 2020 regarding amended tentative approval of subdivision application 17-001699. No physical address assigned. The TMK was 3720604. Subdivision number 17-001699. So we have a stipulation, but first we'll have each party or their representative state the name for the record. So please proceed. Let's begin with the appellant.
Mike Matsukawa, attorney for the appellant, and also on the screen is Kathleen from the association appellant.
Thank you, Mike. And for the appellee?
John Mukai, Deputy Corporation Counsel, on behalf of Michael Yee, Planning Director, County of Hawaii, who's also on screen.
So John, you're a little faint. We might, in the near future, want you to either turn up your mic or sit closer to the mic.
Okay, we'll do.
Thank you. And for the property owner?
Yes, Christy Logan, representing the applicant's property owners.
Okay. Thank you, Christy. So for the parties, there's a stipulated agreement in front of the board that covers both cases. Can I get a response from it was drafted by the appellant, so from the appellee? Do you have any issues?
Oh, none from the planning department and Michael Yee.
All right, and from the property owner?
None from the property owner. We're in agreement.
And there's no objection to the consolidation of these cases? I'd like that on the record.
No.
Nope.
None, Your Honor.
All right, thank you. Hardly honorable, Mike, thank you. So you're asking the board to approve the stipulation. Do any of the board members have questions about this matter and the agreed stipulation? Have you had a chance to review it?
Might be good to have Mike presented.
I'm sorry?
Might be good to have Mike presented since he was a...
Just to clarify things, Mike, could you present the basis for the stipulation?
Well, we had a pre-hearing conference earlier this week, and essentially what had occurred was the planning director was willing to rescind his decisions in both cases, in which case it would make the appeal moot. And therefore, the parties agreed that it would be appropriate to withdraw the appeal in light of the rescission.
All right. With that, I have some hands up. Yes, Christy?
For the record, I think I want the record to reflect that we actually agreed to, we asked the planning department to go ahead and rescind, and it was, I believe, started by my client. I just wanted to make that clarification for the record. Thank you.
Thank you. Agreed. That's how I recall. And somebody else had their hand up? If seeing none, I'd like to proceed to a vote. So this will be a roll call. The question at hand, are we agreeing to receive the stipulation to board matter read into the record? I won't read it again.
I think we need one of them to make a motion.
Could one of my members make a motion to accept or approve the stipulated agreement?
This is Heather Kimball, so moved.
And a second, please.
Second, Steve Harakami, second.
Thank you, Steve. All right, are there any last comments by the board members? If not, we'll proceed to the vote.
Okay. So the motion was to approve the stipulated agreement. And the motioner was Heather Kimball. Heather, how do you vote?
Aye.
And second, Steve Harakami?
Aye.
Stacey Aguiar?
Aye.
Springer K is excused for the meeting. Justin Lee?
Aye.
Neil Thomas?
Aye.
And Chair McCauley?
Aye.
All right, you have 6 ayes.
All right, thank you very much. Thank you to the parties for this. We will move on. Customarily, we would take a break between matters, but this has been a very short run. I'd like to thank the parties for that. So why don't we read into the record the next matter?
Do we have the people available?
Do we have the people available for the call?
We need to-
Let's see.
This is the Walsh data.
So I know Mike Matsukawa is involved in both matters, correct, Mike?
Yes, Mr. Chairman.
Okay, so we need to have Mr. Braswell, Mr. Berscher. Are they available?
See.
No. There's testimony of witnesses for this matter, and they're supposed to be available to support their testimony.
Right.
So are we calling all of them, or they've just been served notice to check in? Because I don't see them up on the screen.
The only
One
one
is-
that I see.
One is on board on Nicole.
Cool, yeah.
Okay.
I don't know if they're planning to call everybody that submitted testimony or
So
what.
if they're not available to support their testimony or be questioned as a witness, do we still accept their testimony?
Well, you can accept it, but it goes to wait if you
Yeah.
can't cross-examine them.
Yeah.
And Alex is on, Alex Roy, good job.
So board members, we're making sure we have the participants in the next matter. So let's take that break if you want to excuse yourself for a few minutes and take care of whatever needs to be done around the house.
Kind of like that would be the right procedure, be able to be that seamless.
I don't want to do the laundry.
None of us do. Get to it. It's not going to do itself.
Okay, so maybe a 5-minute break while we round them up.
Yeah,
Okay.
Bethany's going to go herd cattle or squirrels.
Laundry.
None of us do. Get to it. It's not going to do itself.
Okay, so maybe a 5-minute break while we round them up.
Yeah, Bethany's going to go herd cattle.
Okay, I think I'm in.
Aloha. Sorry, I was waiting for my phone call.
The board finished early, so
Yay.
let's see who's on. Jason's here. David is here. Nicola's here. Andrew's here.
I just kept
Hello, are we all back? I would like to check my quorum. Okay, I see Neil, I see Heather. I've got Steve, Stacey, Justin. I believe I have quorum. All right, so we will now continue with the case of Lorraine Walsh, the Board of Appeals 20-000245, an appeal of the decision by the Planning Director dated December 20th, 2019. This regards the approval issued for a short-term vacation rental registration. The short-term vacation rental is 19-368486, and a non-conforming use certificate, NUC 19-1982. The location, 77-6479 Walua Road, Kailua Kona, Hawaii 96740. The TMK is 377-011-023. Okay, so I'd like to have the parties state their name for the record. We'll begin with the appellant. Ms. Walsh.
Aloha, I'm Lorraine Walsh.
I'm
morning,
Mike
Ms. Walsh.
Mazzucchello, attorney for the appellant.
Thank you, Mike. And for the appellee?
John Mukai, Deputy Corporation Counsel for the County of Hawaii Planning Department. Also present is Michael Yee on screen, and as well as Alex Roy, planner.
Good morning, Alex, Michael. And for the landowner?
Hi, this is Jason Braswell on behalf of Chris Berscher, who's with me here as well.
Good morning, Mr. Berscher, Mr. Braswell. I'd like to ask the board if there's any concerns with any conflicts involving any of the parties that are before us today.
Neil Thomas, none from me.
Okay.
Stacey, can you hear me? Stacey Aguiar. I do have a personal relationship with the Jason Braswell. We both volunteer in a leadership capacity in the community for a sporting event, and I want to just state for the record, this does not prevent me from hearing this case or making an unbiased decision.
Well, thank you, Stacey. Do any of the parties have a concern or issue with Ms. Aguiar's participation on the board?
No, Your Honor.
Thank you, Mike. All right, then we will proceed. Thank you for that, Stacey. Are the parties ready to proceed?
Yes.
Good. First, are there any witness issues from any of the parties?
Witness issues meaning?
People that have you plan to bring to the board on the matter who are not available by video today or have any changes?
I know one is not available, Martha. She's a doctor. And I think everyone else listed is online.
Okay. And for Mr. Berscher?
Our only witness is going to be Mr. Berscher, so we're good.
Okay. Let's see. Exhibits. So because of the nature of the video, the exhibits are a little different, you know, for getting them into the record. So the board's, the chair's intention is to, as you submit the exhibits, each will be considered as they're submitted and be numbered and properly, assuming they're properly available to all the other parties, then we'll proceed in that matter. Is that acceptable to the parties?
Mr. Chairman, I think since the parties had exchanged exhibits previously,
yes.
I think it makes sense to see if anyone has objections to the exhibit so that we can save the time of going, you know, document by document. Because it's expedite matters.
Make sure that everybody has everything and they know what we're talking about.
All right, so
we have to just kind of go document by document.
So, Mr. Berscher, are you comfortable that you have a complete record of all of the potential exhibits?
I think we probably do. Maybe if we want to stipulate to them, we can just put on the record exactly which ones we're stipulating to, and I can sit here and make sure that I'm aware of what those exhibits are, and that'll confirm that we have them.
Okay.
Yeah,
And for the director, Mr. Mukai?
Yeah, on behalf of the planning director, we have no objection to any of the exhibits being introduced.
Okay, so here I have the planning director's exhibit list.
Well, I think we might work off the summary that Melissa prepared.
Okay, do all the parties have the summary? It's titled item number 3 for today's meeting.
Oh, that was only given to the board.
That's only for the board? Okay. Use this as our list?
Yeah.
All right, do the parties have the exhibit list from Mr. Yee, the planning director, dated September 28th, 2020?
No.
No.
Okay. Who was that?
Mr. Chair, I don't think the planning director has any exhibit.
I have a list here that says planning department's exhibit list.
Yes, and it was mailed to
Simply
Ms.
the
Walsh.
record on appeal and the index to the record on appeal.
And it was mailed to
And
Ms.
I have
Walsh.
that as a headline, as a header category, so that's why I called it into the record.
And it was mailed to Ms. Walsh on September 28th of this year.
Yes.
Did not receive it. I received Christopher Berscher's exhibits, but not anything from the planning department. Is there any way to get a quick email copy?
Or what? Would it be a duplicate of any of the exhibits that have been submitted?
Well, the only exhibit listed is the record on appeal and the index to the record on appeal for this matter. I assume the parties have the index to the record on appeal.
Oh, yes, yes.
Yes, we have the record on appeal. We thought you meant additional exhibits. Sorry.
No, it's just that's the title of it. It's an exhibit list. And so we're going to stipulate to the exhibits before the board.
Yes.
From the parties. We have an exhibit, the written testimony of Carl Dean Towle, dated 9/24. This is from the appellate. Does everybody have that?
If it's in the full record on appeal, then yeah, we should all have all of those.
I think this was submitted subsequently, right?
These would be the, let's see, I don't. This is the property owner supplemental exhibit.
Are you referring to Mr. Toll's most recent letter that I believe was sent? Okay, we don't have that.
September 24th, 2020. You don't have the copy of that? This is the appellate, correct?
Right.
Correct.
Yes. Okay. Mr. Matsukawa?
Well, if we start with the appellant's original witness exhibit list, there are 11 items listed.
Yes.
And I think this was distributed to everyone.
Does the property landowner have this list from Mr. Matsukawa dated?
Well, this was, here we go. It was received by us on the 28th. I don't see it.
On the 28th of September, and it's titled appellant's witness list, appellant's written testimony, and the certificate of service. Do you have that from the landowner, Mr. Berscher?
I have some of the written testimony. I don't have the witness list, but I have the written testimony of 4 people. I apologize. I do have the witness list.
Okay. So I note that the individual exhibits that I have on my index of documents are coincide or correlate with the names on the appellant witness list. These might be additional.
I understand from Melissa that these came.
Surrounding neighbor testimony, I believe, is what Dean Toll was.
Yeah.
Hard to follow.
Okay, where am I? Since I'm working off an index of documents that some of the parties don't have, why don't I just do the, I asked the appellant for their exhibit list, which we did. Mr. Matsukala has provided it. For the appellee, I've asked, and they've provided it. And now for the landowner, do you have a witness list? Or
we do not have a witness list. The only witness would be Mr. Berscher.
Do you have any exhibits?
We submitted, yes, we submitted 3 supplemental exhibits. They were property owner supplemental exhibit lists. I'm sorry, supplemental exhibits A through C. That list was submitted on, it was served on July 10th, 2020.
Yes, I have that in front of me.
And then that'll be all of our exhibits.
Okay. The appellant is has this in hand?
Yes.
The property owners and the appellee?
Board members should have that because it's on the record.
Sorry.
Board members should have that. I think.
Okay. So are all of the board members in receipt of these exhibits? Could you confirm that? Raise your hand if you're if you have the records that we're referring to. Neil, do you have the exhibits?
Yes, I do. I'm hitting the raise my hand icon, but I don't know if it's working.
Let's do it the old-fashioned way.
Hey.
Thanks. Let's see. So, are there any other exhibits that we need confirmed as part of our matter today? We have the supplemental exhibits from the property owner, the appellant exhibit list, various orders. We have the record on appeal. All right. So can we stipulate to this, parties?
Yes, we can.
Yes, for the property owner.
Yes, from the appellant.
And yes, from the planning department.
Thank you. So as we proceed to the matter, I'd like to remind the board that what we're going to focus on today and limit is our decisions based on what's in the petition, the record on appeal. The crux of it is Ms. Walsh objects on the grounds the property was not used as an STVR prior to April 1st, 2019, but rather it was a hosted rental. And it does not meet the definition of a short-term vacation rental. The crux of the argument is that the owner and the wife lived on the property as their primary residence prior to the required date, April 1st, 2019. So the presentation of evidence should be focused only on the issues that are in the petition. Our board today will be under Rule 815 in that a decision by the director may be appealed to be reversed or modified or remanded only if the board finds that the planning director's decision is in violation of the code, erroneous, clearly erroneous, or arbitrary, capricious, or characterized by an abuse of discretion. So given that, I'd like the parties to make their opening statements and try to be as concise as possible. Appellant, you go first.
Thank you, Mr. Chairman, members of the board. I think the chairperson quite properly summarized the issues that have been presented. We're dealing with an ordinance which used the word reside in the definition of the activity that we're talking about. Did the owner of the property reside on the building site where the activity was taking place prior to April 1, 2019? The record on appeal, technically, in and of itself, contains information that the board can rule upon without really considering any additional testimony. The appellant's statements are contained in the record on appeal, in quite a lot of emails and correspondence that went back and forth, in which she informed the planning department officials that the owner was a resident of the property at all times during the period in question. The property owner purchased the property, according to the record on appeal, in December of 2017. And so the relevant period is December 2017 to April 1 to 2019. What was the owner doing at that time? What's interesting is that the record on appeal also demonstrates from the application itself by Mr. Berscher. He includes a copy of the property tax records of assessments, and it shows for the fiscal year 2019 that he claimed a homeowner exemption. If you click on the historical assessment of that printout from the website, it shows you that also for the fiscal year 2018, he claimed a homeowner's exemption. Now, the relevance is to qualify for a homeowner's exemption. One declares to the county that he or she, as a homeowner, treats that property as his or her primary residence and does not reside anywhere else. So, that being the case, the appellant had complained repeatedly to the planning officials, as the record demonstrates, that the property owner resided on the property that he was using as a short-term rental to transient guests. For some reason, the planning officials created a standard which is unpublished as to who is a resident. And so the planning officials, for some reason, decided that the property owner was in fact not residing on the property and therefore qualified for the certificate in question. So the question that the board will be asked to determine is really a question of law. The proposed testimony will demonstrate that neighbors regarded him and her as being residing on the property at all times. Planning officials used a standard which is undefined, unpublished, that the landowner, property owner, nevertheless could be treated as if he and she were not living on the property. And so this is the purpose of the appeal. Thank you.
Thank you. Now for the landowner.
Yes. So I'll keep it simple. There's not a, I think as Mr. Matsukawa points out, there's not a factual dispute that my client was living in that property as his primary residence during that time period. One important distinction that I will make is that he did not live in that house long enough for it to become his primary residence under Section 121 of the Internal Revenue Code. That requires 2 years. He wasn't there 2 years. But more importantly, so first, we believe that the planning director's decision was within the discretion given to him under the county code, particularly in Section 25-4-16.1 C1. It allows the planning director to consider not only the evidence on the application, but also, quote, other pertinent information. And in Section C2, it lists a bunch of reasons why the planning director may deny a non-conforming use certificate, but it doesn't list any reasons why he must or shall. And I think clearly the planning director was given great discretion in this area. The other point that I want to raise is Mr. Matsukawa suggests that reside means that it's his primary residence like we would typically think of it, meaning that, you know, I think the record, the evidence is going to show that there were instances in the pre-April 1st, 2019 period where my client went on vacation and he rented out his Airbnb while he was on vacation. Mr. Matsukawa's argument is that that does not count as not residing on the property for purposes of the short-term vacation rental statute. I will acknowledge that that has some appeal, but if you look at other sections of the short-term vacation rental rules, particularly 25-4-16, which requires that an STVR have an owner or reachable person who shall reside in the county of Hawaii, that suggests that the code sections contemplate that that person will actually be on island, physically able. As a matter of fact, in other sections of the code, that owner or reachable person has to be able to respond to a complaint within 3 hours. If you accept Mr. Matsukawa's definition of reside, the owner or a resident could be off island for large portions of the year as long as that's still his primary residence and satisfy the short-term vacation rental agreements. I think what it really comes down to is, I believe the chairperson talked about hosted versus non-hosted, which is sort of the common vernacular that we've used. And I think that is the point, that if you really consider what the short-term vacation rental scheme contemplates, it's this idea that, yes, if you're the owner, if you're having hosted rentals, meaning you're there supervising your tenants, then that's fine. But if you're not going to be there supervising your tenants at the time they're there, that's a non-conforming use.
Okay, thank you, Mr. Berscher. And Mr. Mukai?
We'll just reincorporate and Mr. Berscher.
Mr. Mukai, we're going to need some help with your audio.
Hello? Is that better?
Yes, hi.
Not much.
Not much.
Hello?
That last statement was on advice of counsel. Hello?
Hello?
Yes?
Is it okay now? Is it better?
Is everybody able to hear Mr. Mackay? Give me a thumbs up. Yeah, all right. Yes, John, please continue.
Okay, we would just, again, incorporate Mr. Berscher's argument and just simply add that Mr. Berscher informed the planning department and made representations that the property was not his primary residence. And when asked, he provided a different address, and the homeowner's exemption, which Mr. Matsukawa referenced, really doesn't apply to the approval of the STVR, but rather to the real property tax department. So the planning department, just based on what Mr. Berscher presented and represented, granted the non-conforming use. So where am I?
All right. So, where am I?
Okay, so they've made their opening statement, and so you can ask the appellant to call their first witness. Yeah, I'm sorry.
The appellant or the property owner?
The appellant.
Yeah.
Okay.
All right, so at this time, I'd like the appellant to call their first witness to the board.
Yes, the appellant herself will be the first witness. She has prepared written testimony in advance.
Okay, so this is Mrs. Walsh. Ms. Walsh?
Yes, Mrs. Walsh.
Okay, I'm going to swear you in. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please proceed.
Yes.
Okay.
Ms. Walsh, did you prepare written testimony for this proceeding?
I sent written testimony prior, and I wanted to add something to it.
Okay. Now, before we get to that, so the written testimony that was submitted is dated September 24, 2020.
Yes.
Is that statement something that you intend to present to the board as your direct written testimony?
Yes.
Now, do you have any additions or corrections to be made to this testimony?
Well, first of all, does everybody have that?
Yes.
Yes.
Okay. Yes, I would like to add a couple things.
Go ahead, and what would you like to add?
I'd like to say that we need to go back to the intent of the Bill 108. And I spoke with Karen Eoff, one of the co-chairs of the bill, as did Mr. Matsukawa. And their intent in passing Bill 108 was to manage the impacts of short-term rentals. And it never applied to hosted establishments. It was
Chair, I'm sorry. I'm going to make a hearsay objection to that. You know, Ms. Eoff is not testifying here.
Mr. Chairman, the board has the discretion to receive any evidence that it determines to be material, not bound by the rules of evidence.
Yes, that's true regarding the board's rules. However, I'm going to sustain the objection. Continue.
basically, I'll keep it short. It was to define STVRs and where they're allowed.
Same objection.
Again, because you believe this to be hearsay?
Right. I mean, if she will clarify that the opinion that she's giving about the meaning of 108 is her own, I'm fine with it. If it's what she got from Ms. Eoff, I think we should just clarify as to what the source of this testimony is.
From Ms. Eoff.
I'm sorry, what did you say, Ms. Walsh?
It was from Karen Eoff.
You're referring to a correspondence that was direct to you?
Yes.
And an email?
Yes.
Did you provide it as a part of your exhibit?
No, it came after that was submitted.
Then I'm going to sustain the objection. You should have applied, submitted this for all of us to be able to review prior to your oral testimony.
Okay. I'll continue.
Thank you.
Based on the overwhelming evidence provided, the director allowed a permit for this property that doesn't qualify. I appealed it because this probably isn't relevant either. Just a moment.
Well, is satisfied with this, we could just have cross-examination on our written testimony.
Ms. Walsh, are you comfortable with this testimony that you've submitted in writing to the board?
I am. I did have something to add, though, if I may continue.
Please.
The facts are that prior to April 1, 2019, this property was a hosted short-term rental, and it does not meet the rule for the STVR because the permittee, his wife, listed as landowner, which was the co-host, on Record of Appeal, page 28, where it says Masha helps host. Their two children also lived on the property as their primary residence prior to April 1, 2019. They moved in with a moving van. Their kids went to school every morning. They went on vacation. They were neighbors in every sense of the word.
Ms. Walsh, excuse me, I'm sorry. This is all part of your written testimony that we've had an opportunity to review. So in the interest of expediency, the board doesn't usually hear repetitive testimony. If we have this in hand, then if you have other information or insights you could provide that are unique to you, then that's fine. But otherwise, we'll rely on your testimony that's been accepted.
Okay.
And you'll be available for cross-examination.
Okay. I do have more points.
Okay.
Christopher Berscher attempted to convert the hosted rental, which is listed as a one-bedroom rental of his residence for up to 3 persons, which it shows on Record of Appeal, page 21, 1 bedroom, 3 guests in the Airbnb listing. And he tried to convert it to a non-hosted 2-bedroom STVR for up to 6 persons with his application, which is on the Record of Appeal, page 47, which shows the 2-bedroom, 6 guests. And that application was dated September 21, 2019. This cannot be disputed as shown by the evidence. That's the facts. The first point that supports that fact is that his mailing address, if you look at Exhibit A or Record of Appeal, page 1, did the planning department notice that the applicant address, the landowner address, the reachable person address, and the STVR street address are all one and the same? 677-6479 Walua Road. This alone indicates that the applicant lived at and received his mail at that address. But if there's a question, the further clue is, if you will look on the first page of his application under reachable person address, he wrote in reachable person and applicant address to change when closing escrow at new address, estimated date November 23, 2019. So he stated there that he is moving from 77-6479 Walua Road to another address. Clearly, that's stating he resided there and he's moving after the April 1, 2019 deadline. My second point is his property tax exemption, which Mr. Matsukawa already pointed out, but I wanted to add, because the planning department has some rule that we don't know about regarding how many days he can reside there, the residential property tax exemption brochure in Exhibit 4, page 2, says that you can take the property tax exemption if you reside on the primary residence for more than 200 days. So I think there's a conflict there on the number of days that the planning department says he can reside there versus the number of days that the property tax exemption claims that he can live there. You can actually take the property tax exemption, homeowner exemption, if you rent a room in your house, by the way, but you cannot take it if you don't live there. The last thing is that he resides on the property based on all the evidence we've already provided. Airbnb listings page 22 and 23 of the record on appeal, page 66 and 67 of the record on appeal say that he shares one wall. We live adjacent. Your host will be on the property. You might hear the pitter patter of our children's feet. All these things say that he lived there. So we need to look at what was the intent of the law and what was his intent.
Okay. Oh, please.
One moment.
You will be examined by your attorney and be able to answer to the cross.
I just wanted to end with that Christopher Berscher swore on Exhibit 9 on the record of and the page 12 of the record of appeal that he acknowledged that any misrepresentation made by him in applying for this registration may render it invalid. He may not have understood the law, but this doesn't exempt him from it. And more importantly, the planning department did know the law. You can't make up the rules as you go. I respectfully request that the Board of Appeals rescind the planning director's decision to correct this egregious error. It's not, or to not renew his permit, which by the way is up for renewal. Thank you.
Thank you. So, Mr. Matsukawa would like to proceed with direct?
No, I have no further questions.
All right. So, property owner, would you like to cross?
I do not have any cross.
All right. And for the planning director?
No questions.
All right. Given that, I don't assume there's any redirect. Mr. Matsukawa?
No.
All right. For the board members, do you have questions for Ms. Walsh? Raise your hand if you do. Steve, are you raising your hand or eating? Okay, cool. Yes. I saw a box light up. No? No questions from the board members for Ms. Walsh? All right. Thank you. Thank you, Ms. Walsh.
Thank you.
Do you have any other witnesses, Mr. Matsukawa?
Yes, I have Andrew. He's on the screen.
Okay, from the planning director's office?
No, he's a friend of the appellant and an interested person.
Top middle?
Yeah.
Okay, hi. Okay, please identify yourself.
Thank you, sir. For the record, my name is Andrew D. Mesereau.
Thank you. Mr. Mesereau, do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Could you please advise us where you reside? Write it into the record.
Yes, sir. My primary residence is in Seward, Alaska.
Is that sufficient?
Well, I mean, usually you want to know.
We'd like to have contact information if that's available. Do you have a mailing address you could provide?
Absolutely. My mailing address is P.O. Box 2794, Seward, S-E-W-A-R-D, Alaska 99664.
Okay. Mr. Matsukawa, do you have direct examination for the witness?
Yes, very brief. Andy, on the witness list that the appellant provided, she listed an address of 77-6482 Walua Road. Is that your property?
Yes.
Do you live there from time to time?
Yes.
Do you know the property owner, Berscher?
Yes.
Since when did you know him?
Let's see. My wife and I reside seasonally at 776482 Walua Road in the fall and winter each year. So the time in question, I was residing there during December 2017, which is when I met Mr. Berscher.
How about the year 2018? Did you meet Berscher in the year 2018 as well.
Yes.
And how long would your stays in Kona be in terms of a period of time?
Typically November until April, although during the time in question, I was residing there from December 2017 through April 2018, December 2018 through April 2019, and again from October 2019 until April 2020.
And during that time, did you have an opportunity to observe the use of Mr. Berscher's property?
I did.
Approximately how close is your property from his property?
We're directly across the street, sir.
Okay. So you're on the Makai side?
Yes.
And did you have an opportunity to talk to him or his wife from time to time during those times?
Yes.
And having observed what you saw and spoken to him, what was your understanding as far as his use of the property? Was he a resident in your understanding? Did he live there?
Yes, he was my neighbor that lived across the street from me.
So as far as you're concerned, he was a resident of his property?
That's correct.
And were you aware of any kind of a short-term rental use of his property?
Yes, they had people that would come and stay there while they were residing on the property, just like the people that lived there before them did.
Like the people before them did. So
the previous residents of the property also had a one single rental that they did while they were living on the property.
And as far as you recall, he continued the same practice?
Yes.
He was residing at the property and renting it out to guests?
Yes.
Okay, I have no more questions.
Okay, Mr. Berscher, cross?
No cross.
Okay, Mr. Makai?
No questions.
Any redirect, Mr. Matsukawa?
None.
Nothing. Okay, are there any members from the board who would like to question the witness? Seeing none.
Steve, maybe.
Oh, I'm sorry. Do you have your hand up, Steve? Yes. Steve Hirakami, please.
I was wondering if the last testifier noticed the here in the residence after April 2019.
Could you repeat the question? You cut out right at the critical moment.
Yeah, I was wondering if you experienced or observed Mr. Berscher actually after April 1st, 2019.
I did occasionally observe him at the property, but the difference was there was a increase in volume of traffic of unfamiliar vehicles and people, and I saw the Berschers' presence there diminish proportionally, like they were no longer our neighbors after that time.
Okay, thank you.
Okay, thanks. Stacey? Stacey, did you have a question for the witness?
No, I did not.
Oh, I'm sorry. I apologize. All right. Any other board members have a question for the witness? Okay. So thank you very much for your testimony.
Mr. Matsukawa, may I leave the meeting now? I'm attending another federal fisheries meeting that I stepped out of to give this testimony. Is it okay if I leave you now?
Yes.
Okay. Thank you all for hearing me out. I appreciate it.
Thank you. Catch a big one.
Thank you.
Mr. Matsukawa, do you have any other witnesses?
Yes, next up is David. He's on the screen.
David, could you identify yourself for the board?
Yes, my name is David Kearns.
And your address, please, for contact?
776483 Walua Road, Kailua Kona.
Thank you. I'd like to swear you in now. Do you solemnly swear or affirm that the testimony you are about to provide is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please proceed, Mr. Matsukawa.
Yes. David, you submitted written testimony to the board in advance of today's hearing. Did you not?
Yes, I did.
Yeah. You have a copy before you?
Yes, I do.
As far as you are situated today, is this testimony still your testimony for today's hearing?
Yes, it is.
And essentially, could you summarize your testimony as to the residence and use of the property made by the Bershers during the relevant time period?
Being next door neighbors, I could only write down my observations. And well, you have it all in front of you. We heard them coming and going on a daily basis, getting ready, getting the kids ready, driving away, coming home in the evening, and then we could hear them throughout the evening. So those were my observations.
So in your understanding, they were residing at the property in question?
It seemed obvious to me.
Okay, thank you. I have no more questions, Mr. Chairman.
Thank you. For the landowner?
No cross from me.
Mr. Mackay?
No questions.
Thank you. Questions from the board members for the witness? Yes, Steve.
I have the same question for you. Did you see Mr. Berscher and his family living in the house up to and after April 1st, 2019?
Not quite understanding up to and after.
Yeah, I mean, you're a next door neighbor, so did you see them living there after April 1st, 2019?
I unfortunately do not write down dates as to when certain things happen. I don't keep track of when I see people precisely. And that was 6 months ago. So I think everything in my testimony pretty much speaks for itself.
I'm looking at your testimony and you say in your letter, so I'm just trying to ask you to verify, you said, quote, the Berscher family certainly resided there before and beyond the deadline to file for an existing STVR. So I was just trying to substantiate that.
Yes.
Okay, that's all I'm doing.
Okay.
Thank you. Any other board members have questions for the witness? Did I see a hand go up in the upper right? No? Okay. Seeing none. Mr. Matsukawa, do you have any other? Thank you for your time, sir.
Thank you.
Mr. Matsukawa, thank you. Do you have any other witnesses?
I see Nicola has her name on the box, but I can't see her.
What is the last name, sir? Morosky?
Morosky.
Okay. Are you available on this to us, Ms. Morosky?
Yes, I am.
Okay. Are you in a dark box?
Probably on the phone now.
Okay.
Are you on the phone?
No, I'm on my computer, but apparently you can't see me.
Okay.
Okay. Could you identify yourself to the board, please, and provide a contact address?
My name is Nicola Morosky. My mailing address is P.O. Box 2224 in Seward, Seward, Alaska, which is AK 99664.
Thank you. I will swear you in. Do you solemnly swear or affirm that the testimony you are about to provide is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please proceed, Mr. Matsukawa.
Yes. Did you submit written testimony for today's hearing?
Yes.
And as you stand today, is this statement that you presented still true and correct as far as you're concerned?
Yes.
Is there any corrections or additions that you wish to make to your written statement?
No.
Can you can you summarize your relationship in terms of the distance between your property and the Berscher property?
We live part-time at 77-6482 Walua Road, and that is directly across the street from Chris's and Masha's house.
Okay, so on the Mackay side of the Berscher property.
Correct.
And so essentially, your testimony is that based on your experience and observations and conversations that you've had per your testimony, that the Bershers resided at the property during the relevant time period.
Yes.
Okay, thank you. I have nothing more.
Thank you. From the property owner?
No questions.
Thank you. And from the appellee?
No questions.
Thanks. Do any of the board members have questions for Ms. Morosky? Yes, Steve.
I want to ask you the same question I asked the other witnesses. Do you have any evidence of, I see all the encounters that you had, the many encounters. Were any of these happening past April 1st, 2019?
Yes.
Okay, because your testimony says through 2019, so that when you say through 2019, you mean certainly well beyond April 1st, 2019? Is that correct?
That's correct.
Okay, thank you.
Thank you. Any other board members? If not, Mr. Matsukawa, do you have a to redirect?
None, Your Honor.
All right, thank you. Thank you, witness. Appreciate your time. Mr. Matsukawa, do you have any other witnesses?
No, that would end the appellant's presentation.
Thank you. For the property owner, oh, wait a second.
It's 10:14.
Are people about ready for a short break? Or should we continue? Shrug shoulders, so let's continue. We will continue for another half hour, at which point we'll take a break. Please, can the landowner, do you have any witnesses?
Yes, we're going to call the landowner, Christopher Berscher.
All right, thank you. Mr. Berscher, could you please identify yourself to the board and your contact address?
Yeah, my name is Christopher Berscher. My contact address is 77363 Sunset Drive, Kailua Kona, Hawaii, 96740.
Thank you. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
I do.
All right. Please continue.
All right, Mr. Berscher, when did you purchase the property at 77-6479 Walua Road?
November 2017.
Okay, and when you purchased that property, did you move your family in there?
Not right away, but yes.
Approximately when did your family move into the house?
Late December. Wasn't an exact date because we had a slow move from another property on the island.
Okay, and you and your family lived there until when?
Or let's say December 2019.
Okay. Can you describe to me the process by which you applied for your non-conforming use certificate?
So I went to the planning department in person, and they have kind of office hours where you pull a number and you can sit face to face with one of their clerks and present your application that you have in process, and they will give you feedback. They'll answer questions, and I did that twice, and they were very helpful. And in both of those consultations, I presented the evidence I had, and I informed them that the prior short-term rental activity was done with me mostly residing on the property.
And let me ask you, these conversations that you're talking about, can you tell me the approximate time frame of these?
You mean the length?
No, like when they occurred, the date.
Early September, just a couple weeks before the application deadline.
Okay. And so when you submitted your application, you wrote on there a note, and for everyone's reference, I'm looking at page 1 of the record on appeal. You've got a note on there that says reachable person and applicant address to change when closing escrow and new address, estimated date 11/23/19. Do you see that?
Yes.
And that was, you wrote that because you were moving out of the 776479 Walua Road to a new residence, right?
Correct.
Okay. And you had told the planning department that in your preliminary discussions with them as well?
Correct.
Okay. You said that you had rented well, let me step back. So you were renting your ohana, and you were using Airbnb as the platform to do that. Is that correct?
Correct.
And the majority of the time you were there in the property while those renters were occurring?
That's correct.
Was that always the case?
Not for every reservation.
Approximately how many times did you rent the property via Airbnb when you weren't physically at the property while the renter was there?
How many days or how many reservations?
Either one, whichever you can remember.
At least 4 reservations.
Okay. And during those 4 reservations, where were you?
So for 2 of them, I was in New Zealand on vacation, and for 2 of them, I was in Vancouver, Canada.
Okay. And do you know approximately how many nights that was?
I haven't totaled it up, but at least 15.
Okay. And then one other question: in your discussions with the planning department or anywhere else, did you ever represent to anyone or try to make anyone believe that 776479 Walua Road was not your family home anytime prior to April 1st, 2019?
No, I did not.
Okay. Okay, I have no more questions at this time.
All right, Mr. Matsukawa for Cross.
Yes. Mr. Berscher, I assume you acknowledge that you claimed the homeowner exemption on the residence for the fiscal year 2018 and 2019. Did you not?
Yes, I acknowledge that.
And are you aware of the conditions upon which the homeowner exemption is available?
Yes, I read the pamphlet.
And so as far as you're concerned, you were complying with the county's requirement for property tax purposes that this property was your primary residence.
Yes, by that definition, for property tax, yes.
So is it your understanding that for property tax purposes, you treat the property as your primary residence, but for the purpose of transient vacation rentals, there's a different definition for residence?
I wasn't applying under that pretense. I wasn't claiming that it wasn't my primary residence. So I don't know if they apply different definitions. It's not my area of expertise.
No, so I'm just getting to your understanding. Is it your understanding that for purposes of the short-term vacation rentals ordinance, that you were not residing on the property during the time period of 2018 up to April 1, 2020?
Yes, answer the question. Can you repeat the question? I'm sorry.
Is it your understanding that the word reside under the ordinance question?
Excuse me, Mr. Matsukawa, just a moment. If everybody could go on mute, absent Mr. Berscher and Mr. Matsukawa, perhaps we'll have less crosstalk or noise. Thank you.
Let me put it this.
Excuse me, sorry. And if while you're waiting for the question, if you would put yourself on mute, or for Mr. Matsukawa waiting for the answer, if you would go on mute, that might solve the problem. Please continue.
Could you explain to the board what your understanding of the word reside on the building site means under the transient vacation rental statute?
I didn't have a specific understanding of that word at the time.
Going through some parts of your application on your federal Schedule E, which is on Record on Appeal 16, you refer to two rental properties that you were claiming income or losses on. Parcel A, which is redacted, and parcel B is the Walua Road property. And for the type of property for number B, which is the Walua Road property, you say number 3 is a vacation short-term rental. But on the number of fair rental days on the column, for the redacted parcel A, there's a representation of 90 days. And on the number of days for property B, which is the Walua Road property, there's no entry. Is there a reason for the absence of any entry for the Walua Road property for 2018?
So I use a tax accountant. So I don't prepare these forms myself. I simply provide the documentation to the tax accountant and he completes this for me. So I was not aware that those days were left blank.
Did the planning officials point out this omission to you?
No.
Okay. The next few questions don't really go to your residence, but just for clarification, on your TAT return on record and appeal, page 31. This is for the period ending March 31, 2019, which is only for 1 quarter. Did you provide the planning officials for information on the years 2018, to your knowledge?
You're asking if I provided transient accommodation tax information from 2018?
Yes.
I don't believe I did.
Okay. And for your GET on record and appeal 33, again, this is for the quarter ending June 30th, 2019. So did you provide information to the planning officials for the year 2018?
I don't believe I did.
Did planning officials ask you for any information on TAT for 2018?
No.
Or for GET information for the year 2018?
No.
Now, in the record and appeal, there's a statement. Let's see, let's go to record and appeal 97. This is in the form of an email from Mr. Roy to Ms. Walsh. And there's reference to your living arrangement in the last sentence. New information regarding their living arrangements have been made, and you are not privy to all the information that would allow you to make an accurate inference. What information did you provide to planning officials on this so-called living arrangements that were new?
Simply the handwritten note about my primary address changing after the application date, but before the, at some point in November, I expected to have a new address.
And on record and appeal 98, Mr. Roy, again, in an email states that they do reside on the property for a portion of the year, but not the majority. You see that? It's about in the middle of the page.
Again,
yes, I see that.
98. Yes.
So you represented to the planning official that you do reside on the property.
Yes.
Okay. Yeah, I have no more questions.
Thank you. Mr. Mackay?
Yes, Mr. Berscher, my name is John Mukai. I represent the planning department, and I just have a few questions for you. Do you remember after you submitted your application that someone from the planning department called you to ask for more information? Do you remember that?
I do remember getting a phone call from planning, but I don't remember being asked for more information in that phone call.
So if Mr. Roy were to testify that he talked to you and wished to get more information, you would have nothing to dispute that. Is that fair?
Could you restate the question? I'm not sure I understood it correctly.
So if Mr. Roy would testify about what he talked to you about, you don't have any independent recollection of what happened. Is that fair?
Yes.
Okay, nothing further.
All right. Redirect.
Just one question, or I guess one line of questioning. When you were you transparent throughout the process with planning department regarding which home you were living at which time, which I mean, were you clear with them as to when you were living at 77-6479 Walua Road versus when you moved to your new home?
Yes.
Okay. I have no further questions.
Thank you. Board members, do you have questions for the witness? Yes, Mr. Hirakami?
Yeah, do you remember before you actually applied for the short-term vacation rental application, do you remember what planning person you talked to? Was it a front desk clerk? Was it an actual planner? Who did you talk to? Could you identify what the level of planning personnel was?
Front desk clerks, two different front desk clerks.
Okay, and so you kind of like you're very transparent. You obviously I see it in the application. Did you do any personal research on looking up short-term vacation or what the rules were for applying? Did you do personal research?
Yes.
And did you know that that if you lived in that home and just co-hosted, that you were not able to get an application? Did you realize in looking over the rules for the application?
No, I was not under that impression.
Okay, thank you. No further.
Any other board members have questions? Yes, Heather?
Thank you, Chair. And please advise if this is not an appropriate question. Mr. Berscher, for the tax years of 2018 and 2019, did you file this property as your primary residence in your state income taxes?
Yes. She said thank you.
I'm sorry, Ms. Kimball, if you had a follow-up to that, you're on mute and we did not catch it.
Nope, that was my only question. Mahalo.
Thank you. Any other board members? Okay, if not, then I'd like to thank the witness. So do you have any other witnesses, Mr. Berscher?
No other witnesses.
I'm sorry. Who's the attorney?
Braswell.
Braswell.
No other witnesses.
All right, thank you, Mr. Braswell. My apologies. So Planning Director Pelley, do you have any witnesses? Mr. Mackay?
Yes, I would just have Mr. Alex Roy testify and just focus his testimony on what Mr. Berscher represented and what he provided to the planning department with regard to his primary residence. So that I'm just going to focus him on that.
Thank you. Mr. Roy, could you address the camera?
Mr. Chairman?
Yes. Yes, Mr. Matsakawa.
I'm going to object to Mr. Roy being called as a witness because he was not listed as a witness by the planning director until the deadline had passed. So we object that this is untimely. Mr. Roy's statements do appear in the record and appeal, but I don't think he should be allowed to testify if he was not timely identified as a witness.
Didn't we just have the appellee's direct witness list and exhibit list?
We thought there was no objection to the list at the time of when we started.
Mr. Matsakawa, do you have correspondence from the County of Hawaii dated September 29th, 2020, hand-delivered, Michael
Yes.
Yee, Planning Director, Witness and Exhibit List?
I do.
Okay, do you see on page 2 the witnesses listed?
Yes.
Do you see number 5, Alex Roy?
Yes, I do.
So what is the distinction you're making here?
At the original pre-hearing conference, I think the deadlines were set. So Ms. Walsh did comply with the deadlines when she made her submittal as to her list of witnesses.
Yes.
And this designation of Mr. Roy as a witness was made after the deadline that the Board of Appeals established at the pre-hearing conference.
We have our,
The 28th.
yeah, what is our calendar that we set?
I believe it was the 28th.
So,
And so it was received.
yeah, council advises me that we set a deadline of September 28th. Is that what you, does that correlate with your understanding, Mr. Matsukawa?
I believe it was a lot sooner.
Okay.
This is the one where the dates got moved. Yeah. So I don't know if I have that in.
We're looking for our records as far as the calendar that we set at our pre-hearing conference.
However, no objection was made to this list at the start of the hearing, so.
Yes.
It should have been made then.
I think there were two.
This is,
please.
well, this is Jason Braswell. I just wanted to note, I don't have that deadline written down, but I did see that Ms. Walsh's witness list was filed on September 25th, so I can't imagine that for the appellant's witness list to be filed 4 days later would be problematic.
Yes, and further to that, at the beginning of this hearing, when we were dealing with exhibits and witness lists, I read into the record that this particular document was part of what I had as an exhibit, and it was listed. So, Mr. Matsukawa, I'm going to allow this witness to proceed. Mr. Mackay, continue.
Thank you. The County of Hawaii Planning Department would call Alex Roy.
Mr. Roy, please provide your full name and address.
Alex J. Roy, 184202 Lehuanani, Mountain View.
Thank you. Do you solemnly swear or affirm that the testimony you are about to provide is the truth, the whole truth, and nothing but the truth?
I do.
Okay, Mr. Mackay, proceed.
Mr. Roy, what is your occupation?
I'm a senior planner with the Planning Department, Planning Division.
And part of your job duties would include processing of STVRs, which are similar to the one applied for by Mr. Berscher.
Yes.
With regard to Mr. Berscher, I just want to focus you on information he either provided to you or told you which regarded his primary residence at around the time of his application.
Okay. Yeah. The application came in and immediately saw that there was a note concerning the residence, the reachable person, and the location of the STVR. So I contacted, after reviewing the rest of the file for completeness, the application, I contacted Mr. Berscher to discuss what that meant and to inform him that the rules required that it be an unhosted rental in order to be processed as an STVR. At that time, he had stated that for the majority of the time, or greater than, 50% of the time, he was not in residence, and that for a lot of the rental issues, he was not in residence. So it appeared to be an unhosted rental.
And did Mr. Berscher provide a separate either mailing address or residence address to you?
He did. In fact, he provided an address. He had a girlfriend's address and then the address that he provided of his new property in the application.
Now, at some point in time, did you ever reach out to Mr. Berscher, and if he can explain to the board why you did that?
I reached out to Mr. Berscher just to confirm, because again, there seemed to be an issue with residents, and because the rule did not allow full-time hosted rentals to become STVRs, I wanted to confirm that he in fact was not residing on the property for the majority of the year.
Okay, and that was the basis, one of the bases for you granting his application. Is that fair?
Yes.
You made a recommendation to Planning Director Michael Yee, is that correct?
I did.
And
yes.
did Mr. Yee ever tell you that you needed to go back and do more investigation or make sure someone's not lying, or go with your telescope to make sure someone's not there or anything like that?
No, all we can go off is in the application.
Okay, thank you, Mr. Roy. I have nothing further.
Thank you. Mr. Matsukawa?
Yes, Mr. Roy, can you tell me and the Board of Appeals, where in the ordinance does it say that the property owner need only reside on the property for a majority of the time, or as you said, during the period of rentals need not be present on the property?
That's not listed in code.
So
I'm
that
sorry,
is,
Mr. Roy, we're going to need something clearer than that. I can't hear you.
It is not listed in code. That was a discussion with the managers and with the deputy director.
that is your interpretation of the ordinance, in other words.
No, it is not my interpretation. That would be the managers or the deputy director.
And who are the managers and the deputy director?
I spoke to Norin Kato and then April. The deputy April Superintendent.
Did you solicit the advice of the County Corporation Council?
I'm going to object. That's potentially attorney-client privilege. But
I'm not asking for what might have been stated. I just want to know, did he consult, not what was told to him?
Overruled. Continue, Mr. Matsukawa.
Did you consult with Corporation Council as to the managers and directors' interpretation of the word reside?
No.
Thank you. No more questions.
Thank you. Mr. Braswell?
Excuse me.
Oh.
May I consult with my attorney?
We're in the middle of cross. If you can do that on a sidebar, go ahead. But as far as this board matter, we're going to continue. We'll take a break, by the way. Just at the end of this witness, we're going to go on recess. So I can advise you of that. And I will allow time after the recess for a redirect. So continue, please.
Okay, thank you, Chairman. Just a couple of questions for you, Mr. Roy. When you were discussing Mr. Berscher's residence with him in clarifying whether or not he was a full-time resident of the property, did you distinguish whether you were talking about at that moment in time versus at some earlier moment in time, or was it just what his current state was?
I don't think there was. I don't think we distinguished what time frame. I think there was some assumptions made that we were talking about what related to the application only.
And you were having were these conversations with him in approximately December 2019? Okay, let me show you.
There was only one or two conversations I had with Mr. Berscher.
Okay, can I direct you to page 98 of the record? Have you got that? Can you show him that? Was that email sent around the time? Well, okay, if you look there, that's an email that you sent on December 23rd, 2019. Is that correct?
That is correct.
Was that sent about the time that you had that discussion with Mr. Berscher?
That seems about right, yes.
Okay. Let me ask you one more question. So I believe you testified previously about your understanding of the definition of the word reside with respect to how the code defines short-term vacation rental. Is that correct?
Yes.
Are you familiar with the requirements of the code that short-term vacation rental have a designated owner or reachable person who shall reside in the county of Hawaii?
Yes, that's definitely, yes.
Do you understand reside to have a different definition in that context than it does in the definition of short-term vacation rental?
As a government employee, I can tell you definitions are very specific to situation. So yes.
Okay. All right, I have no further questions.
All right, thank you. Yes? All right. Prior to allowing the planning director to redirect, Steve? We're going to take a recess. We'll come back for planning director's redirect and then board members' opportunity to question the witness under oath. So at this point, we're going to take our promised recess.
How long, Chair?
5 minutes. Thank you. As you return to the screen, I'll wait till I see a quorum, and then we will resume the Board of Appeals hearing of October 9th. So, Stacey and Steve. Yeah, Neil. Justin, got him. Heather. I think we got everybody. All right, and we have our witness, Mr. Roy. You're in attendance, and I'm reminding you, you're still under oath.
Yes, Mr. Roy, this is John Mukai for the Planning Department. Could you clarify your last answer regarding the code requirements? If you could, regarding time.
Yeah, I just had forgotten that the designation of time frames was actually in Hawaii County Code under section 25-6-31.
I'm sorry, could you read that into the record a little more clearly?
So this is regarding the question of residence and timing, and I had stated that I wasn't sure of the code, but I have now found that code reference, and I will present it to you. So this is in regards to timing in this section 25-6-30 of Hawaii County Code. And section 31, which talks about, in essence, just to simplify this, we go off the timing of residence goes off of state law, which the cutoff is 180 days, is considered short term and not full time. And so that's where I came up with, or where manager and the planning department had come up with that designation of 180 days. So if you were less than that, on the property, then you wouldn't be considered to be residing on the property.
Okay,
Mr. Roy, just for clarification purposes, council and I are at code 25-6-30. Could you point us to the subsection or clause that identifies scheduling?
Sorry, I have to go through.
Or timing?
I'm sorry, I'm not prepared. I should have got more just to go through it with me. I'd have to go through. I'm sorry. I know it's in here. I just had a very quick discussion with the manager, and he pointed me to that section, but now I can't seem to find it. The timing stipulation.
All right. So then, without proper citation, then we're going to strike that reference. We can't find under that section any reference to timing schedules. Mr. Mackay, any other redirect?
Well, Mr. Roy, when Mr. Berscher signs his application for STVR, does he sign an affidavit that he has complied?
Yes.
Okay, nothing further.
All right, Mr. Royce, remain available. Board members, do you have questions for the witness? Yes, Mr. Hirakami, and then Mr. Lee. First, Mr. Hirakami.
Yeah, I'm looking on the record of appeals from pages. I see a lot of back and forth. after December 23rd, 2019, your email at 8:54 said the application was approved and you're waiting for the applicant to pick it up. But however, I see a lot of emails prior to that in October, like October 16, and back and forth between Lauren and you and Ms. Walsh, alerting the department that this doesn't apply because he resides on the property. And this was well before the December application approval. Do you have any obligation to do any kind of research on whether somebody notifies you that the person is actually residing there, or are you just taking the word of the property owner per the application?
No, I mean, any neighbor that presented testimony or comments towards an applicant's registration would be taken into account. So when there was some concerns from neighbors regarding resident status, it was taken into account, but without definitive proof. If Mrs. Walsh had provided, proof that on every single day she took a photograph or noted, then that would be something that would be able to use. But often neighbors aren't, without definitive proof. I have to. It's a he said, she said kind of situation. So at that point, I have to revert back to the application.
Okay. And another question, you in part of your reply to Ms. Walsh, you said that on his tax filings for 2018 and 2019, 2018, he indicated that he filed taxes for STVR. How did you determine that was an actual STVR or it was a co-wholesale? How do you make that determination on a tax rate?
No, we just had to ensure that TAT was they had registered and had registered prior to the deadline, and then they needed some proof that the property had been rented as an STVR prior to the deadline, which he provided. So based on the checklist of the application, the information was complete.
So basically you kind of like rely on the honesty of the applicant when he tells you something, rather than a research when somebody knows for sure, like a neighbor. We've heard from 3 neighbors that live directly next door, right across the street, that appears to have evidence of him actually residing when he co-hosted the bread and breakfast. So I just wanted to know that you kind of rely on the honesty of the applicant.
Well, yeah, and one part-time resident and one neighbor, having concerns. Anybody who works in government knows that every single project and application has dissent. So
right.
We have to be, otherwise we would never approve anything, because everybody always has a problem with everything. So we have to temper our review with what is provided to us by the applicant and the neighbors. And then again, without very stringent and strict proof, I can't go off of just somebody's word, a neighbor's word. And yet I assume the applicant is not lying to me. Yes.
Thank you. I don't have anything else.
Okay. Justin?
Thank you. Mr. Roy, if Mr. Berscher informed you that he had resided at the property for greater than 180 days, what would you have done with his application?
I would have then turned it over for review by maybe one of the managers for possible denial, as it did not, that may not have fit the, or would not have fit the definition to approve the STVR.
Okay. I have no follow-up. Thank you.
Any other board members have questions for the witness? That was a close call, Heather. Okay, seeing none. Let's see, earlier there was an issue that the Ms. Walsh raised. Mr. Matsukawa, do you have a redirect if you, would you elect to take one at this time?
Yes, I just have a short question, short area. I'm sorry, I just have a limited area of examination.
For Mr. Roy.
For Mr. Roy.
Please continue.
Okay, Mr. Roy, throughout your testimony, you've never mentioned Mrs. Berscher, who is also one of the applicants. Is there a reason for that?
I don't hear an objection.
Sorry. You guys, I wasn't quite prepared. There's the application first page.
I'm sorry, I cannot hear the response.
Yeah, I'm looking for, hold on. I can, Christopher Berscher was the only listed applicant. So I'm not sure what you want me to do.
Mr. Matsukawa, do you have the application in hand?
Yes, I do.
Okay.
Yeah, it's landowner applicant. The applicant is listed as Christopher Berscher.
Yeah. And the landowner is indicated as Christopher and Mariah Berscher, correct?
That's what it says on the application.
And so isn't it the code requirement that the owner not reside on the building site, the owner, which would include Mrs. Berscher?
I can't speak to Mrs. Berscher.
Did you address her residence as had been noted by some comment letters in the record on appeal?
I'm not sure how to answer that. I never spoke to her, and it was only mentioned in passing, and up until today, to be honest, I thought it was a girlfriend. I didn't know it was a wife. So I don't look at the landowner's name just other than just to make sure under the real property tax that the landowner has signed the application.
Clear that up.
No, but what I'm getting to you is the definition of short-term vacation rental in the code speaks to where the owner does not reside on the building site. Did you ever address the fact that Mrs. Berscher also resided on the property site?
No.
In your review?
No.
And the chairperson struck your testimony as to the code section 25630, but you also mentioned something about a state law. Have you been able to produce that citation?
Not the exact HRS citation, but the 180 days is not a code. It's from HRS tax section. In fact, the mayor was using it for the long-term definition.
Do you have a citation that the board can refer to?
I don't have the specific citation now.
Okay, thank you.
Okay, thank you, Mr. Matsukawa. Let's see. The planning
Am I
director
allowed
have
to
any
add
other
something?
witnesses? I'm sorry. Yes,
Am I allowed
Ms.
to add
Ray?
one comment?
You'll be allowed
later
rebuttal, and so let me just clarify that the planning director has no other witnesses after Mr. Roy. And then, because before I jump into rebuttal, go on, Mr. Mukai.
Yeah, Mr. Roy would just like to add something.
Yeah, it's HRS. The reference for the 180 days, the tax is HRS 237 D-15.
I have nothing further.
Okay. So, Mr. Matsukawa, your client, are you going to call her as a rebuttal witness?
Yes, sir.
All right. So then we're going to finish with Mr. Roy. So, Mr. Roy, thank you for your testimony. I'm sorry, does any other board member have any question for Mr. Roy before I dismiss him? Yes, Heather?
I actually don't have a question, but I would like to request a moment to review the statute that was referred to by Mr. Roy.
I'm sorry?
Yes, you can do that.
Yes, we can do that. We will do that. But,
Thank you.
Let's stay online.
Mr. Chair, this is John Mukai. I think Mr. Roy has one more citation.
And that would be HRS 237 D-1-07.
Okay, everybody get busy.
They're over there, but I don't know.
Chair,
How current.
Chair
Yes.
Elliott, Stacey Aguiar, I do have a question for either Mr. Roy or the planning department in general. My question is it the position of the planning department that any requirement to define hosted versus non-hosted qualification in the applications were consistently based on this 180-day rule?
Board can call witnesses, and if they want to call the planning director, they can.
It's not really
Okay.
my place to discuss
You can address that to Mr. Roy or the planning director, Stacey?
Yes, my question is addressed to Mr. Roy or Mr. Yee.
All right, so Mr. Roy, you want to take a shot at that?
I'm not in a position to just talk about the planning department's position on anything.
Oh, okay. Fortunately, we have Mr. Yee here. Mr. Yee, I'll need to swear you in after you identify yourself.
Michael Yee, Planning Director.
And I guess you live at the County of Hawaii?
I live in Hilo, Hawaii.
Thank you. You're well known to us. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. Please, can you recall Ms. Aguiar's question?
Yes. The question is, do we consistently apply the 180 days for the applications? So a little background will help. There were about 3,000 STVR applications made for permitted zones and 1,000 applications about for non-conforming use. So that was 4,000 applications that we generally received by September, end of September, that we had a very short timeline to have to process, generally 90 days on the NUCs. Otherwise, they were automatic approvals. The planning department used to review we did about 800 permits a year prior to this. So on top of 800 permits, we threw on 4,000 applications that we now had to review with no significant resources and additional staff to do so. So that context is important because with 4,000 applications, but let's say just take out the non-conforming use ones, that was 1,000. The question is, how consistently did we apply to 180? And I can't recall. There were 1,000 applications I signed, right? And obviously, I don't go in every single one to review every little detail. I will tell you, out of the 1,000 applications, the issue around primary residence was typically not a big issue. You might find one or two that were in the gray, but generally it was fairly, I guess, clear to both the applicant and to the planning department if something was hosted or not. This was clearly one where information was being presented that it may be in question. So I don't want to sit there and say the 180 days, was it consistent? I generally would say it was consistent, but it's not as if we had to use that bar in a really contested way with an applicant. I think most applicants, we told some like, you're hosted, and then they withdrew. We didn't get challenged by them if we told them we felt that they were a hosted rental. There were some applications we denied that we never got into the 180 days because it was really, they were saying they were residing there. We didn't have to get into the number of days they were residing. And we probably have a couple of appeals coming regarding that. So so to answer the question, yes, I believe we were consistent. But I also want to point out, it's not as if we had like 20 of these kinds of cases to have to get into the details around the 180 days. Thank you.
Thank you. Ms. Aguiar, do you have any other follow-ups with Mr. Yee or Mr. Roy?
No, that answers my question. Thank you. Heather is raising her hand.
Okay, Heather.
Hi, Mr. Yee. My question is, so the application of 180 days, that's not written or codified anywhere in rules? That is just a choice that you folks made, am I understanding correctly, as the determinant of residency? Is that written anywhere?
I don't think it was written anywhere in the vacation rental bill or in our rules, but I'd have to refer to that, but I don't believe so. You're right, at a certain point, you had to draw interpretations. I will tell you, in a law, in an ordinance that was so far reaching on 4,000 properties, it was gonna be hard for an ordinance to capture every scenario that could occur. And so, the ability for me to try to interpret and to make sense of something that was newly being applied to our island means you have to use that discretion to try to draw a line somewhere.
Follow-up, Chair?
Please, go ahead.
I just want to confirm that the choice to use 180 days as the benchmark was a determination that was made on your discretion or the department's discretion, and applied here based on the lack of other written opportunities to specify residency or to define residency.
I'll confirm that in this application, we certainly applied it. I again, with 1,000 NUCs, I can't recall how many, and I can't recall any offhand that we ever got into the situation to have to draw this 180-day line. Like I said, many times we might have communicated that to folks and people chose to apply or not to apply. I can't bring up when that was used. I can definitely tell you on this application we used it, and I can't recall of another one offhand that we did.
Okay. Heather, is that sufficient, or do you have more questions?
I have one further, which is I may have be looking at the wrong code, but I think I'm looking at the correct HRS 237-D dash 15. Why was that particular measure of residency chosen? It does not seem, in my reading of it, it does not seem to be directly applicable there. I think, can you speak to that?
SB 237. Can I?
237.
I'm going to defer to Alex because I think he has a response.
15 sets the period, I think.
Mr. Roy, continue. You're still under oath.
Yeah, we believe that the definition was HRS section 237-1. The D15 may not be correct.
Okay, but in which case I think I may be looking at the wrong statute.
Yeah, HRS 237-1 is a definition of transient accommodation.
Okay. Any other board members have a question for either with? Yes, Justin.
Thank you. So I looked at the definition of transient accommodation. I guess the question, I'm going to pick up Ms. Kimball's question, because short-term vacation rental and transient accommodation, they're similar but not necessarily the same thing. So I guess I'm wondering what the reasoning was to use the definition for transient accommodation for short-term vacation rental.
Is that directed at Mr. Yee or Mr. Roy?
Well, first, Mr. Roy, I guess, if he has an answer to that.
I just want to clarify again that it's one more time, last time. The reference is HRS 237-D-1.
Yes.
Okay. But I cannot speak to why we use that definition.
Okay.
So Justin, take a second whack at it. You have Mr. Yee there.
Mr. Yee, do you have an answer to why transient accommodation is used?
Because they have to pay TIT tax at that point.
Okay. If it's a hosted rental, do they still have to pay transient tax?
I'm not an expert in that area, but I believe so. Any rental less than 179 days or less is, I believe, subject to TIT.
Okay. Thank you, Chair. I have no question.
Thank you, Justin. Do any other board members have a question for Mr. Yee or Mr. Roy? Yes, Heather?
Hi, I have one more question for Mr. Roy. You said that when you took in the application, you did look at the property tax assessment. And did you note, just to clarify for the record, you noted at that time that the homeowner's exemption was taken and that a homeowner's exemption can only be taken with residency or of 200 days for the state of Hawaii?
The homeowner's exemption was not part of the application review because the homeowner's exemption is a different department's kuleana.
Ms. Kimball, anything further?
I just want to make sure it's clear for the record then that part of the application process was not to look at is the exemption status on the property.
Yes.
Okay, thank you. Okay, any other board members have questions for the witnesses? We have two on the stand. I have a question. Mr. Yee, are you familiar with the Rule 23, short-term vacation rentals, rules of practice and procedure?
Sure.
Rule 23 dated April 9th, 2019. You were a signator. Are you familiar with the Rule 23?
Generally, yes. Sorry, I don't
Okay.
have a copy in front of me. I'm in the Kona office today.
Okay. So under definitions, it provides a definition for a short-term vacation rental, in which it states it's a dwelling unit which the owner or operator does not reside on the building site. It has some other qualifications as well. Are you familiar with that definition?
Yes.
Okay. There's no qualifier in that definition. Was there a reason there's no qualifier as far as what constitutes reside on the building site?
I cannot recall.
Okay. From purposes of this board, we deal with citizens who have concerns, like some of the petitioners, witnesses in this matter, and you would think they would rely on something like this document as guidance as to what are the rules and rights and obligations, starting, and you begin the document with a definition. So this matter, I think, is in front of us, perhaps because of this ambiguity or this lack of clarity regarding something as simple as a definition. Do you have an explanation for why this definition does not conform with your policy?
No, only in that, in something so new with a vacation rental bill, from an ordinance to bringing it down to rules, we are imperfect and flawed individuals in trying to craft for every little detail. And so this would only be another area that if we ever redid rules in the ordinance, that we would look for more clarity.
I appreciate that answer. Thank you. Let's see. So if there's no further questions for the witnesses, I'm going to, I'm sorry? Oh, Mr. Hirakami, please.
Mr. Yee, if I know you're deluged with a lot of applications, but during the application approval process, if it was pointed out to you that the owner took a homeowner's exemption, that would indicate that he resided in the house for more than 200 days, would that make you disapprove the application? Because it's got to be one or the other, right? If it's a homeowner's, if it was appointed, I know you don't look at that as part of the application, but just say it was pointed out to you that the person had a homeowner's exemption, would that automatically disqualify the person?
Yeah, definitively no. We did not use that. And I would also suspect if people really wanted, be it the people who crafted the ordinance or the rules really intended that to be the case, we would have stated that specifically somewhere. I will say, and again, sometimes whether or not it makes logical sense or not, there are things that, let's say, exist in tax code, which may have an effect on planning, but again, that resides in tax code, and so it's not an issue to us in planning. So whether or not somebody had an exemption may certainly infer certain things that affect something, but we're not looking to regulate the tax code. In this case, I will tell you, in most cases, if there was an inconsistency between what an owner was claiming with an exemption and they were being issued a vacation rental permit, RPT have been informed just from our issuance of permits to know that that exemption would likely have to change. So there was communication between our department and with real property tax. And we certainly collaborate with RPT. So, but no, we did not use that as a factor. If you had an exemption, that would restrict you from getting an STVR permit.
Thank you. Thank you, Steve. Any other questions from the board members? If not, I'm going to allow the appellant's counsel to cross-examine Mr. Yi, if you so desire.
Yes. Mr. Yi, in reference to your reliance on the transient accommodation tax law, you felt that was a reliable source to examine in order to determine residency. Is that correct?
Yes.
Yet at the same time, Mr. Roy said, in reference to another tax code, which is the county's real property tax code, Mr. Roy said, oh, that's another agency's Kuleana. Is that your opinion as well?
Again, in trying to sort out things that were not made clear, you're going to try to pull sources to make a call. In this case, we use the transient definition.
Well, what I'm getting at is if the real property tax code, which addresses the specific subject of residence, was deemed to be irrelevant outside the planning department's Kuleana, why would a state tax code, which does not specifically aim at the owner's residence, why was the tax code that the state had relevant if the real property tax code was not relevant? Why wouldn't both be irrelevant?
The simple answer would be I try my best to figure out where the line lies when it wasn't clearly stated somewhere.
Okay. And as Mr. Roy testified, he could not recall consulting with Corp Counsel. Is that your understanding?
Correct.
And when the legislation for Bill 108 was prepared, did Corp Counsel prepare the ordinance?
Well, with any ordinance, it's reviewed by key departments, so it would have included Corporation Counsel.
And when the Rule 23 was drafted, was Corp Counsel involved as well?
Yes, they were.
And to your knowledge, this issue of defining residence was not addressed, or was it addressed by Corp Counsel during the legislation process, to your knowledge?
Not specifically in this issue around primary residence. And the reason why I add a little qualifier, and I can't remember where we landed on it, I'd have to go back and refer, but the question came up around the usage of somebody only renting their house, let's say, out for a couple of weeks during Ironman in Kona. And whether or not, how did that, affect primary residence or not? In the end, I believe we landed like it doesn't affect it. But I think that, trying to understand the implications of somebody renting out only a couple of weeks during one special time of the year, be it Merry Monarch or Ironman, was certainly tried. We tried to be flexible with that. I'd have to go back to see how we adjusted for that. But we never got into, I think, a big debate over primary residence and, I guess, foreseeing this lack of clarity.
And just a final area. The ordinance refers to a dwelling unit on which the owner does not reside on the building site. Would you agree that the reference to owner in this case would be to both Mr. and Mrs. Berscher, who were listed on the application as owners?
Generally, yes.
Okay, thank you.
Thank you. Mr. Braswell?
Yeah, I have a short line of questioning. Mr. Yee, looking at your rule 23-5, or not your rule, but the planning department's rule, it requires STVRs to have an owner or reachable person who shall reside in the county of Hawaii. Are you familiar with that?
Yes.
Do you apply the same 180-day definition of reside in the context of that rule?
No. I mean, I haven't been faced with that question. And have I received a complaint that somebody who's the reachable person isn't the reachable person? I can't recall receiving a complaint about that and having to decipher whether or not somebody's here 180 days or not. I haven't been faced with that question yet.
I mean, you understand that rule 23-5 is requiring that there be a person on island connected to a rental while the rental is occurring. Is that correct?
Well, that was certainly the intent.
Right. I don't have any other questions.
Okay. So again, planning director or Representative Mr. Mackay, do you have any other witnesses? I'm sorry, first I'm going to excuse the current witnesses under oath. Mr. Yee, Mr. Roy, thank you for your testimony. Now, Mr. Mackay, any other witnesses from the planning director?
No.
Okay, let's see. Appellant, do you have any rebuttal witnesses?
Yes, I think Ms. Walsh wanted to testify in rebuttal.
Okay, Ms. Walsh, earlier I swore you in. I consider you still under oath.
Ms. Walsh, was there any specific subject that you felt necessary to rebut?
I just wanted to comment on Planner Roy's comment that there were only 2 part-time neighbors that testified to residency. We actually, in the record of appeal, have Dean and Denise Toole on page 68 and 86, Susan on page 69, and of course myself and my husband who live next door, and Marta, I can't pronounce her last name, Dorig, I believe, who was a witness who submitted written testimony but wasn't here today. Are we going to hear that, or has everyone read that?
Well,
that's my only point.
Yeah, we'll get to that. That's all.
Okay, any other rebuttal witness, Mr. Matsukawa?
No. Excuse me, rather than say, yeah, that's true. No further rebuttal witness.
Okay. And Mr. Braswell, do you have a rebuttal witness?
Yeah, I'd like to ask Mr. Berscher just a couple of questions.
Continue. Mr. Berscher, you are still under oath.
Mr. Berscher, who is Maria Berscher?
Maria Berscher is my wife.
And do you live together?
Yes.
Have you lived together at all times?
Yes.
Okay, so there was, just so we're clear on the record, there was never a time at which she was living at the property and you weren't, or vice versa?
Correct. We always lived at the same property.
Okay. And the other question is, when you were in communication with the planning department, did you ever indicate to them that you were living in the property at 77-6479 when you in fact were not living in the property?
No, I did not represent that.
Okay.
In that way, ever.
All right. That's all I have.
All right. Any questions by the board members? No. In this process, if any board members have a question for these rebuttal witnesses, just raise your hand and I'll recognize you. Do you have any other rebuttal witness, Mr. Braswell?
No.
Okay. Planning Director, Mr. Mackay, do you have any final rebuttal witness?
No.
Okay, then I'm going to close the evidentiary portion of the hearing and move on to the closing arguments. So in this matter, the appellant will go. I'm sorry?
Michael Matsukawa.
Oh, Mr. Matsukawa, go on.
Yes, one matter of procedure, Dr. Martha Deering had submitted written testimony but could not attend, so she could not come and testify. To the extent that she did submit a written statement under penalty of perjury, I would ask that the board consider and receive her testimony. The parties may object, but
What page is her testimony in the record on appeal, and at what page?
it was submitted with the appellant's list of witnesses and written testimony. It's the, I think it was the last of the written testimony.
And what date was her testimony submitted?
Together, her letter is not dated, but it was submitted as a package.
Yes.
Yes.
So we have that in the index of
Yes.
documents. This was submitted as an exhibit, yes. So go on.
Yes. No, so she was not present, so we did not formally offer her testimony because she was not present for cross-examination. So I'm saying that even though she was not able to attend, we are asking that the board receive her written testimony in any way, in any event, under the board's discretion.
Of course, and thank you. So the board members, you're familiar or you're aware of this testimony by Ms. Deering, Dr. Deering, undated but submitted on with the documents for this meeting. General relevance is, or specific relevance, has to do with the dates of residing at the residence. Is that correct, Mr. Matsukawa?
That's correct.
All right. Thank you. So now, please, Mr. Matsukawa, as long as you have the mic, we're going to have closing arguments now, and appellant goes first.
Yes, Mr. Chairman, members of the board, I think the issues have become fairly clear after the evidentiary portion has been completed. The question is, the ordinance is very clear on its face that says the kind of activity we're involved in is one where the owner does not reside on the building site. While the word reside was never defined by the county council or by the planning department in the rules, one must give the word a plain and ordinary interpretation. That's the general prevailing rule. There's a rule in the county code that talks to how the county code should be interpreted. That's in the general administration section, where the plain and ordinary meaning of a word should be given to any provision in the code. And so the word reside, while it may have not been defined by the county council or by the planning director in the rules, is made by the county council. The county council uses the word resident or reside in other portions of the county code, which includes the real property tax code, and generously provides property tax relief to property owners if they reside on property for more than 200 days a year. And so the applicant owner in this case did submit and obtain a homeowner exemption, indicating that they, quote, were permanently residing on the property in question. Now, what seems unusual is the planning officials have chosen to reject any reference or reliance upon the real property tax code, which is a county ordinance, yet defer to another tax law, which is the state TAT law, and then apply the state definitions to the word residence or reside in the county code. That is a non sequitur. You know, you can't say tax laws are irrelevant and reject the county real property tax code, yet accept and rely upon the state TAT law. You know, you can't have it both ways. So this is a situation, and whether the planning officials were or were not acting in good faith is irrelevant. Whether Mr. Berscher was acting in good faith is really irrelevant as well. It's really coming down to a matter of law. The county code enacted the ordinance as they did the owner reside? So you have to apply a plain and ordinary meaning to this term. Without any further elaboration, one must conclude that the applicant and the owner were residing on the property. Therefore, their activity did not qualify as a STVR. Simple as that. And I think the board should grant the appeal. Thank you.
Thank you. And for the landowner, closing argument?
Yes, thank you, Chairman. I don't, Mr. Matsukawa, the maxim that he cites about interpreting the code according to its plain language, or the word reside according to its plain language is true, except for when a statute or code or whatever is ambiguous. And I think if the last 2+ hours have shown us anything, it is that this code section is indeed ambiguous. And I point that out just because Mr. Yee himself admitted that he would define reside differently in one section of the ordinance versus how he would define it in another section of the ordinance. I think that's the definition of an ambiguity. I would urge the board to consider the ramifications, not only in this case, but long-term of defining reside in this capacity where you only have to be on the island 200 days a year or something like that, without respect as to whether or not you're in the property when it's being rented, because I think we all sort of have this hosted versus non-hosted distinction, and I just, it doesn't jive with me that, you know, if you are living in Alaska for 5 months of the year and 7 months of the year you're in Hawaii, and then the 5 months of the year that you're in Alaska, you rent out your place on Airbnb. I don't think that's a hosted rental, and I don't think that's what's contemplated by this code section or Bill 108 or any of that. We believe that the planning director or the planning department made its decision with full knowledge of the facts and circumstances. We believe that the determination that they made was within their discretion and that it should be upheld.
Thank you. And for the planning director, Mr. Mukai?
Yes, thank you. Just very briefly, under the circumstances, when we look at the taxation, if you look at HRS section 237D15, application of tax, specifically B1, if a person lets a transient accommodation for less than 180 consecutive days, it shall be presumed that the accommodation furnished is for a transient purpose. Now, under the circumstances, under the situation provided, the planning director made a policy decision and determined it was the 180 days. So there's no will or anything like that. It's basically what Mr. Berscher or any applicant provides, and also the applicant is required to sign an affidavit that he or she has complied with all the necessary steps in his application for the STVR. And based on what was presented to the planning department, under the circumstances presented, we believe the planning director acted properly in this case.
Thank you, Mr. McKay. So now it will come time for the board to discuss and deliberate. So does any member have any observation or discussion to begin? Mr. Hirakami.
Yes, I think this is, just a situational thing that it's unfortunate. Obviously, Mr. Berscher was very transparent. He made an application with what he knew of the codes. The planning department was deluged with thousands of applications. And I think, unfortunately, this one slipped through the cracks. But, this law is designed for the neighbors. It's designed for residential areas that are primarily other people's primary residence. So I would say that this is nothing against Berscher. All of the testimonies from the neighbors say they're lovely people. They got lovely daughters, and so it's not against Mr. Berscher per se, but it's against the unknown. Who comes into that house and what kind of noises they make, what kind of disruptions they make to the neighborhood. So you got to think the intent of this law was to protect the neighbors, not owners that are renting it out and don't live in the home. So at least when he co-hosted, he would have some opportunity to say, hey, you guys got to keep it down. I got neighbors across the street. You guys are making too much noise. But absent of that, he's got no control over parties being thrown in the house and everything like that. So I think the intent of the law was clearly to protect the neighbors. And this is nothing against Mr. and Mrs. Berscher. And this is not against the planning department, because I hear Michael said, hey, these were unusual times, and so guarantee with thousands of applications going through, things like this are going to unfortunately slip through the cracks, and I think this is just a clear example of that.
Okay, thank you, Steve. One approach to take here would be to put a motion on the floor and then argue the motion. So in interest of expediting the matter, the chair will entertain a motion at this time from one of the board members. Yes, Heather?
So I will go ahead and make the motion that the board grant the this appeal BOA 2000245 in favor of the appellant. And I'm not sure, you'll have to help me with the wording. Or is that sufficient?
I think that's sufficient. I don't see Bethany scrunching up her forehead. So does the board understand Ms. Kimball's motion, which is to grant the appellant's request that the planning director's decision be remanded? No.
You could remand, or you could just overturn it.
You want to overturn it or send it back to him, Heather?
I'm going to suggest that we overturn it.
All right.
In this
So
motion.
the motion is, okay, thank you. Is there a second available for that motion? Oh, Neil.
Oh, Neil.
You'll second the motion? So it's been moved. Go on.
Okay, we have a motion to grant the appeal in favor of the appellant to overturn the director's decision. Motion made by Heather Kimball. How do you vote?
Well, they may have more discussion.
Oh, okay. After the motion's on the floor, is there any discussion from the board members on the motion in front of us? Yes, Neil.
There. There we are. Trying to get
I was going
unmuted.
to ask you, you need to get a signer behind you.
I seconded
go on.
this. I seconded this motion because it really is the question before us that needs to be discussed, and I'm not clear in my own mind where this goes. I would like to hear whether there is a difference between these different ways of interpreting how long one has to be in a property to be to be considered a resident. It seems to me that the record shows that no matter how you measure it, 180 days, 200 days, or whatever, that Berscher resided in the property. And so the question of whether there needed to be some judgment call by the planning department, the planning director, as to which law to apply because of the absence of a definition in the ordinance itself, seems to me maybe it doesn't matter, but help me out with that part, if the other members could.
Yes, Heather? Heather, are you on mute?
Sorry about that. Yes, I'll respond to what you are talking about, Neil, and I will agree that the ordinance is unclear, the rule is unclear with respect to the two uses of the word reside. However, I think regardless of whether or not the planning department used the property tax rule to determine residence in this particular case, the fact that Mr. Berscher took the property tax exemption, which only be taken if you have resided in that property for 200 days during that term and filed taxes with that as your primary residence, regardless of whether or not 180 days was the standard. If he took those exemptions, then it implies that it was at least 200 days that he was there. So I think either way you look at this, even though there's ambiguity around the definitions, and I think you also have to take the word in the context of the whole sentence, and you can't just take it alone, and also with intent. So that is why I put forth this motion. I think it was erroneously derived at by the planning department.
Okay. Any other board members have comments or discussion? I have a comment to discuss this motion. So with this Board of Appeals, we frequently find ourselves like Alice in Wonderland, confronting Humpty Dumpty and finding out a word means whatever I say it means. So given that we have a rule here, Rule 23, that cites frequently in the rule various Hawaii County codes. We have testimony here today that cites state statute. It's incumbent upon us to follow that hierarchy, that code trumps rule, law trumps policy, law trumps rule trumps policy. Mm-hmm. So one of our issues here at the board is constantly policies, both written and unwritten. And as a board, we have to fall back on the rule of law. That's why we're here, is to provide fairness in applying the law to all who come before us. So taking the planning director at his word that he was practicing good faith in the intent of this rule for the short-term vacation rentals, and the sense that he had to deal with an imperfect rule and under constraints of time and personnel, I'm sympathetic to the decision that he made, and he pointed out that he'd like to have a do-over and have a chance for correctives, and I think matters like this bring that to the fore. So given that, I've come to my conclusion, and if no one else has comments, then we're ready for a vote. So, Neil?
At the beginning of the meeting, you quoted something, and I wonder if you could find it for me again, which is the standard which we are to apply. It's not that we have to find clear error, but what is that phrase that we apply in these kinds of cases?
Council's provided, so.
I do think this is binding.
I'm sorry?
The board's rule.
Yeah, the board's rule is binding. Is that your question?
Yes, that's why I need a reminder as to what it says.
Okay. So we have to determine the planning director's decision is in violation of the code or any other applicable law, is clearly erroneous in view of the reliable, probative, and substantial evidence on the whole record, or was arbitrary, capricious, or characterized by an abuse of discretion or clearly unwarranted exercise of discretion. That would be our determination or our understanding of the standard by which we judge this appeal.
Does that mean in lay terms we're looking for a big screw up?
Any of those things could constitute a screw up, large or small, and it's our responsibility to determine the weight of that.
To me, this case is on the cusp because you have clear and convincing evidence from multiple neighbors that they were residing there, but you've also got the planning director saying, I'm really not bound by that. You have what to me seemed a somewhat cavalier comment from the staff that if we ever listened to the neighbors, nobody would ever get anything done because they just always object, and I'm not sure I quite agree with that approach. But be that as it may, the planning director says, I had to make a call here in the absence of any clear direction. These other things are only guidelines, and so I want you to sustain my judgment in this case. I think that's a tough call.
Yes, Justin?
Thank you. I guess this is in response to Neil. I focus on the email exchange between Mr. Roy and Ms. Walsh, where Ms. Walsh is saying basically we have, evidence that Mr. Berscher is a resident, and then Mr. Roy indicated that Mr. Berscher represented to him contrary evidence that he wasn't residing there, or at least not within the definition of a short-term vacation rental. So it sounds to me like the planning director or the planning department made a call based on the representations of Mr. Berscher, but those representations, at least as relayed to us by Mr. Roy, seem contrary to Mr. Berscher's position at this hearing, which is that he was a resident and he never tried to hide that fact. So if he was a resident and never tried to hide that fact, it seems to me that the planning department would conclude that he doesn't qualify for a short-term vacation rental. So I guess that's just where I'm coming from.
Thank you.
Any other board member? Steve, yes, please.
Yeah, well, obviously, when you're dealing with so much volume, you're not going to have the same kind of scrutiny over applications. So a few are going to pass through and get approved, and then people that are aware of that and say, no, hey, that's wrong, are going to point it out. I think that's why there is a Board of Appeals to see if, and like I said before, there was no error on the either parties. We relied, planning department relied on Mr. Berscher the planning department was overwhelmed. I don't think anything was malicious or done intentionally. However, I do feel that this one slipped through the crack, and we are alerted, and our duty is to rule how we see it. Was he a resident or wasn't he? And it appears with the evidence presented that he was indeed a resident. We have many testimonies from close neighbors and everything like that. So I think that, like I said, it wasn't intentional. It was just one of the thousands that slipped through the cracks. And I think we have to rule on the facts presented to us.
Thank you. And any other, Stacey, do you have your hand up? Yes?
Yeah, I think I just have one opinion, and I think in absence of a true definition, the planning department did do the best they could in interpreting definition, and in this particular circumstance, addressed the concerns of the opposition and still came to a determination that they are continuing to stand behind. And I think my question on consistency was trying to determine how often this question or situation of opposition has come up. So for me, I think all parties in good faith proceeded with the direction to the best of their ability to interpret a flawed law. That's just my commentary.
Thank you. Have we heard from all our board members? I'll just say one last word as a member of the board. I thought that this matter was well definitively presented by the neighbors to the planning department prior to the determination being made by the director. And so I think that absent any fuller testimony, we know from the record that there was considerations made to the concerns of the neighbors at that time, and that the department apparently was of the mind to rely on other matters or again, statutes and code matters to provide clarity on what was a imperfect rule regarding short-term vacation rentals. One thing that I noticed in the testimony that I'll just observe on is that are there other short-term vacation rentals on this street, in this area? Because things have to be taken in context, as was mentioned by another board member earlier, that things aren't taken in the singular or the absolute. Everything's relative to the community, and that's why we're here as a board to balance all of that. So given that final comment, I will now like to call for the question.
Okay, this is on the motion to grant the appeal in favor of the appellant to overturn the director's decision. Heather Kimball?
I vote aye.
Daniel Neal Thomas?
Aye.
Stacey Aguiar?
No.
Steve Hirakami?
Aye.
Springer K is absent. Justin Lee?
Aye.
Sharon McCauley?
No.
You have 4 ayes and 2 noes.
So the matter is decided in favor of the appellant, and the action of the planning director is overturned.
So you want to ask
Mr. Matsukawa, can you draft the findings of facts and decisions of law and the order required?
Yes, I can do that. Time limit? Time limit?
24 hours. No, 30 days, Mr. Matsukawa.
Thank you.
Thank you. At this time, the parties are excused for the matter, and good luck to all. And for the board, we'll get on with the business of the day.
Thank you.
Thank you.
Thank you. First, I'd like to congratulate the board on avoiding executive session. We really dodged a bullet there. Well done, group. Let's see.
So the minutes, I think.
First, yes, the approval of our September 11th, 2020 minutes. Have all of you had a chance to review the minutes of our previous meeting? Yes? Okay. Are there a motion to approve the minutes? Thanks, Steve. And a second? Thanks, Stacey. It's been moved and seconded. Could we have discussion? We're good? Thanks. Unless you just vetoed the minutes, Neil. No? We're good. All right, thank you. It's been moved and seconded. Yeah. We're going to have a roll call vote. Prepare.
Okay, motion to approve the minutes of September 11, 2020. Steve Hirakami?
Aye.
Stacey Aguiar?
Aye.
Singer K is absent. Heather Kimball?
Aye.
Justin Lee?
Aye.
Daniel Neal Thomas?
Aye.
And Chair McCauley?
Aye. Thank you. Let's move on to the administrative matters. We'll ask Diana for a status on the update of appeals filed.
There's no change since last time. Everything is in the same place. Nothing new to report.
We stay stuck.
Mm-hmm.
Okay, thank you, Diana. And let's see, Bethany, could you give us an update on the outstanding petitions?
Sure. What would you like to hear about? We have, let's see, we have 8 cases scheduled for our November meeting, 12 cases scheduled for December. So I think there's still some movement happening about some continuances, but that was updated this morning. We're also still waiting on the LUC's determination to deal with those cases, 19 cases regarding the STDR.
And I think if I can add that, we determined according to the Hawaiʻi administrative rules that after a hearing, they have 120 days to issue the decision. So they made the decision in August, so I think we could hope to get that in December if they take the full time.
Okay.
All right, so board, I don't know if who will have the privilege of chairing this board in the future. So I'll just say that, for instance, the LUC matter, we have these pre-hearing conferences, and petitioners, might request, an expedited review. The chair makes the determination based on a motion by the planning director that we should defer any decision on an agricultural farm dwelling issue until we have the printed LUC ruling. So that's something that the chair decides, and every motion except dispositive motions, the chair may manage within these conferences. So what I'd like to do as the chair is, if any of you wish to, I could try to arrange that you could observe if you wanted to, and just see what goes on in that hearing, okay, or that conference, I should say, just so that you are more immersed in what this board is, and should you ever sit in this seat, you'd feel perhaps more comfortable dealing with the matters at hand. So I'll just put that out there. It's something I thought of last week when we were sitting in a pre-hearing conference. So just let Bethany or Diana or myself or somebody know, and we'll try to accommodate that either by Zoom or you come down and you have to get in that hermetic spacesuit that the senators are going to use to vote for the Supreme Court.
I'd also like to thank Jim because kind of behind the scenes doing these, I think we're able to actually make a lot of movement happen with cases, kind of wakes people up and makes them think about where they're at with the case, and either they withdraw or they make a more concerted effort to try and resolve things with the planning department, or they're hell bent to go forward, and we know that too. And we're trying to do that, you know, to save a lot of time for this board, but, you know, I guess the backside is that Jim is giving an inordinate amount of time to, you know, helping this process, for which we really thank him, and, you know, we just want you to be aware of that. Not to scare anyone from considering taking his job at some point, but he's really helped.
Yes, Neil.
I'd like to add that as a shout out to Jim for presiding over the other case that was on the docket today. Had you not been able to, you know, effectuate some kind of settlement of that case, none of us would have the afternoon off here today.
Ain't that the truth, brother? Yes, Heather.
Yeah, I was going to say the same thing. Every time we get a notice that something has been withdrawn, or when we got the notice that this case there was a stipulation for withdrawing it, I think that you must have done a lot of work behind the scenes. So mahalo plenty for all of the effort that you put in to make our lives easier. That's appreciated.
Thanks, Heather. I don't want to take undue credit. You know, John Mukai and Diana and actually what you'll find, I'm sorry? April. But what you'll find is that most people, when faced with a deadline or their own hanging, you know, would like to avoid that moment. And so getting the people together, whether it takes a whip or a rose, you know, the thorny end or the flower, you just move people towards a conclusion. And this, we know, if you've been involved, and Steve will remember this, we used to have nothing on our docket. We'd go months. I think we went a year once without a hearing. And we're just inundated now. We have 8 in November, Bethany said. Yeah. November, December is chock-a-block, and we're building up January. So, you know, we need to try to resolve these matters between the appellant and the appellee before they get to us.
Well, and that's an excellent strategy. I can speak to that as a vice president of West Hawaii Mediation Center. You know, there's just nothing better than getting people into a room with a neutral party who can help them find their own solution. And I think that's what's happening in these cases. So a shout out for that. And if I might, just on a slightly different topic, because I've kind of raised this question with staff here recently. I'm new and learning what is considered normal. And it struck me as a question that needed to be asked as to why, when we have a case like Walsh today, for instance, where we have this big record of that's mostly petitioner offers of evidence and argument, and we get nothing but the record on appeal from the planning director. And that just strikes me as odd. Why wouldn't we expect that the planning director would write some kind of memo, some kind of argument as to why the petition should be denied? You know, and would it have saved, I guess we have to ask ourselves, would it have saved time today if we had a memo from the planning director that said, look, here's what happens in our staff, here's the challenges we face, here's the difficulty that we have in interpreting something that has no rule or definition, and so here's what we did, and that's why we came to the decision that we did. We would have, as Paul Harvey used to say, the rest of the story. And I just was raising this question of, is this normal?
Thank you, Neil. Steve, do you have something to say? You had your hand up.
Yes. Yeah, I do. I was kind of wondering if this last case that we heard, if they had a pre-hearing conference with you and the director, because I think that some of these things could have been worked out without us involved.
I guess I would say we did.
We did.
But one thing that happened is that Ms. Walsh did not retain counsel until the 0 hour.
Oh.
And so, you know, sometimes it's much more challenging with pro se people, especially if they have a strong opinion about things, to work in the same way as with counsel. And by the time she did get counsel, there really wasn't time for us to hold a pre-hearing conference. I did reach out to Mr. Matsukawa to see if he was going to be, if he wanted to proceed or if he wanted to have more time since he was so new to the case. He wanted to proceed. And we have to weigh that because people do have the right to a hearing.
Okay.
And so we did make those efforts in that case.
Okay, so in other words, you had a pre-hearing conference before she retained the attorney.
That's correct.
Yeah, some months ago. Yes.
Yeah.
I
So.
think I retained the attorney in the past week or something. Yeah, very recent.
Well, I know that saves a lot of time and trouble. You know, you get attorneys, and it's kind of like judges' chambers. You know, a lot of decisions get made in the judges' chamber and doesn't go out in the courtroom. So I appreciate that you took care of that Kona thing, and I think that maybe this one, if they had she had retained the attorney earlier, that this might have never reached us. So yeah, just my comment.
Yeah, we're all familiar with that old saw about a lawyer with the fool representing themselves has a fool for a client. So, you know, we frequently at the board have to deal with citizens, petitioners who are not familiar with rule, law, policy. They just feel aggrieved, and it requires a lot of coaching. And in this instance, Ms. Walsh got the inference, got professional help, which all of us need from time to time, and in today, she won the day. Whether it would have mattered whether Mr. Matsukawa was there or not is not relevant in some respects, perhaps, based on the determinations you board members made based on the evidence. To Neil's point, as far as getting a brief from the planning director on matters, you know, to explain, you know, how they came to it, should they be the appellee, as they were in this instance. One of our concerns, Neil, is that we are under the umbrella of the planning department. We, at the Board of Appeals, we have staff that supports us. And we don't really want to give the planning director any courtesy. If he wants to make a brief or a memorandum, that's his discretion. But I'm not going to coach the planning director and his corp counsel about facilitating their case. You know, if they wanted to leave it ambiguous and murky, that's on them. They're professionals, and we're here to make sure things are equal for the public and all concerned.
I get it.
Was
Thank
I
you.
listening to that? Huh?
I get it. I get it. I think that it's not our job to help a party make their own case. It's perhaps sad when they choose not to, but it's not up to us to say otherwise.
Yeah.
Although in other cases we've had, they've written briefs and distributed it before the hearing. So that's not unheard of coming from the corp counsel, you know, so they do that.
Yes, that's very true. We had the Mauna Kea case, was briefed all over the place, multiple times. All right, let's see. So we've had our
Sure, I just
report.
want to make a correction.
Okay.
I think I misstated. For the November meeting, we have 3 cases on that docket right now.
Okay, 3. And then December is the chock-a-block one?
Yeah.
Yeah.
All right, that's our little Christmas present. Double-digit issues. All right, are there any announcements by anyone? Yes, Steve?
I just wanted to know, that there's a pretty lengthy one, I think, coming up. Which agenda is that on, the Hu'onua?
That's December, yes.
December, okay.
Yes.
Yeah, Bethany just looked it up, but, yeah. So we'll just deal with that as if it gets presented to us, we'll deal with it.
Well, we'll be doing a pre-hearing.
Yeah, we'll have a pre-hearing conference on that. If anybody wants to be notified of when that pre-hearing conference is, I'll ask staff to alert you, and you can perhaps Zoom in.
I won't be Zoom. I'm not allowed to Zoom.
Oh, yes, Steve. Oh, you're cool. All right, Stacey.
I was just raising my hand that yes, if staff could alert us. I do think sometimes the information or you do get additional information from those hearing meetings. So I think uncomplicated ones that we might be given the opportunity to observe.
This is Diana. Just to be clear, there isn't a discussion of the merits during a pre-hearing conference. It's really directed to procedure. So, I want to make sure everybody understands it's not like we're discussing the merits of the case without you guys present. It's limited to procedure, like issues of witnesses, exhibits, and that sort of thing. Timing and their efforts, perhaps, to work with the planning department.
Yes, Steve.
So would the sunshine law prevent more than 2 members to go on those pre-hearing conferences? Because I think sunshine law allows 2 people, but not 3.
Yeah, I think that's a good point, because those are those have been kind of viewed as settlement conferences. So I think if we had more than 2, it would be a problem.
Yeah.
Okay, because my thoughts, we can't have Zoom in that conference room, so the only way that we could potentially do it is if one of us had a phone and we simply put you on mute and you could observe via FaceTime or something. But again, it was just an idea on my part, and I didn't clear this through council or staff, so it might be a dead end. I'm just shooting from the hip. All right, anything else? No announcements? No one's having a grandkid or something? We're all pretty old. All right. All right, well, thank you again for your participation on the board. But if there's no other matter, then I'm going to adjourn the meeting.
I just, Chair. Oh.
I adjourned.
Okay.
Yeah, Steve.
No, I just wanted to make an announcement. Wanted to wish Heather good luck in this next month. She's, it's an important month for her. It's the last leg of her month. So I don't live in your district, but up to you.
I think that's cool, Steve. I compliment anybody, including Bethany here, who threw their hat in the ring, and enters the fray. So good luck to you, Heather. Better luck next time, Bethany.
Yeah. Thank you so much.
All right. Good luck. Take care.
Thank you all.
Have a great day.